The agreement was for a cap of 6 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Are there any additions or corrections?
Just argument from the defense.
Not from the state.
In addition, I have received the jail incident reports, which have been turned over to counsel. Have you both had an opportunity to review those?
I have.
Also, I have received this morning and now reviewed, it looks like 4 letters of support that Ms. Holmes brought today. Mr. Smith, have you had an opportunity to review those as well? All right, then Ms. Holmes, you may proceed.
Thank you, Your Honor. In looking at the PSI report, Mr. Lewis does have obviously previous criminal history spanning from juvenile and...
All right, everyone, buckle up, because this is going to be a wild ride in the courtroom today. We're talking about Denzel Lewis, a man with a long and complicated criminal history, facing serious charges for unlawful possession of a firearm by a felon. Already, we know there's a plea agreement on the table with a 6-year cap. But as we dive deeper, you'll see why the judge might not just take that at face value. From traffic stops to letters of support from family and friends, this case is loaded with tension, contradictions, and courtroom drama that you will not want to miss. Stick around, because the twists start now.
To adulthood. The priors that he has, it appears, with burglary of a habitation. It looks like 3 cases, but they ran concurrently, in which he was placed on probation and had a revocation, in which he was sentenced to 8 years in TDC. He has since been discharged from that, Your Honor, and after being released, there was this traffic stop, which resulted in a firearm being found in the vehicle in which Mr. Lewis was driving. Obviously, in reading his response to the PSI officer, I would allow him to elaborate more on that. Obviously, he did plead guilty to the offense, taking responsibility, and we are seeking probation in this case, Your Honor. We believe that at this point in Mr. Lewis's life, he understands, obviously, being incarcerated before, that it's not somewhere that he wants to go back and spend potentially 6 additional years of his life. He would like this opportunity on probation to have that opportunity to spend and get back on track with employment, to take care of his family and provide for his family. And reading those support letters, Your Honor, he does have support here from family and friends in the community that are willing to step up and help him to make sure that he is a productive citizen and he gets back on track. He understands that there's just certain things with being a convicted felon that he cannot do. And I think at this point he understands that, Your Honor, and we are asking that the court give him the opportunity to be placed on probation and to finish his term while on probation.
Well, I guess before we go any further, I want to make sure I understand, because Mr. Lewis, your version of this is...
Here, where the defense really tries to set the stage. They're pointing out Mr. Lewis's past, from juvenile offenses all the way through adult convictions, including multiple burglary cases. The big takeaway here: he's been in trouble before, served time, and now claims he wants to get back on track. The defense emphasizes the letters of support, the family backing, and the idea that he could rebuild his life on probation. But watch closely. Even as they make these arguments, the tension builds, because the prosecution already has a record of repeated violations and behavior issues. The courtroom is bracing for a clash of credibility versus sympathy.
That it wasn't your gun, it was in your girlfriend's purse, and you didn't even know her purse was in the car, much less the gun was in the purse in the car. So either you are guilty or you're not guilty of the offense. And so if you knew about it, then you're guilty. If you didn't, then a jury needs to decide.
I'm pleading guilty because I was driving the car, and by me driving and then finding the gun,
But the law, that's not what the law is. Okay? So you don't get to just take a deal or plead guilty because that's what you want to do. When you were here before, you stood in front of that clerk, you put your hand up, swore that you were going to tell the truth, and I said, are you pleading guilty freely and voluntarily? Are you pleading guilty? because you did what they charged you with.
And I was, and I still am.
Okay. All right, Mr. Smith?
Judge, I think he's been given probation before. It was not successful. He's been revoked. The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
Now pay attention here. This is where the story gets really tricky. Mr. Lewis claims the firearm wasn't his, it was in his girlfriend's purse, which he supposedly didn't even know was in the car. The judge immediately zeroes in on the law. Guilt can't just be convenient. If he knew about the gun, he's guilty. If not, then it's a jury issue. This is the kind of moment that can make or break a case. It's not about what's easier, it's about the facts and the law. And already you can sense the tension in the room as the judge challenges his version of events.
So, Mr. Lewis, one thing I noticed in several of these letters that friends and family members said, I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
I speak on that, y'all.
Sure.
That case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed up off of my file, but it still shows up. That was not on me. It's somebody.
It's more than one time.
But
So hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this. Your response, according to this, is that that person should have asked the officers how big your penis, anyway. Since they want to be talking about you, they should have told them about that too. Then, on March 25th, before that, a week, to another officer, and these aren't the same officers, it's not the same person saying the same thing about you, somebody has some vendetta against you. So on March 25th, started to do rounds. Notice that you were watching the person doing rounds.
Brace yourself, because this part of the transcript is jaw-dropping. The judge meticulously goes through multiple incidents over months where Mr. Lewis allegedly engaged in sexually inappropriate behavior toward female officers, ignored repeated orders, and used abusive language. We're talking a pattern, not isolated mistakes. Even when he tries to deny these actions, the judge lays out the evidence with precision. And here's the key: multiple officers, multiple reports, multiple months. The court isn't just seeing one moment of bad behavior. It's seeing a consistent pattern that directly challenges the defense's claims about his character.
Had his hand over his midsection as if he was rubbing on himself. March 18th, another different officer. Notice monitoring the bunk. There you are, laying on your back, stroking your penis in a back and forth motion, told not to do so. January 24th, 2025, you're in trouble for walking around. This one, notice the way you're laying on your bunk in a way, making motions under the blanket, walked past, turned around to see if you were still doing it. Then you supposedly look at this officer and say, "I'm not doing anything while you lifted the blanket up for that officer to see it. January 4th, another time, being told to be quiet, do what you're supposed to do, didn't do it that date. December 29th, another issue of not following the rules. December 17th, another infraction for arguing and not following the rules. So if there was one time when they got the wrong person, that's one thing. That's over and over again. You disrespecting female officers who are in there just doing their job.
I don't know, sleep on my back.
Sir, we're really going to do that?
You ask me and I'm telling you, John, I sleep on my back.
Uh-huh.
I have sisters. I have a mama. I don't do that. Them people write whatever
They're making this up on you? That's terrible of them to do that.
If you look at my cases report, ma'am, I don't have any cases on none of that. I don't have any time. I'm not on no restriction on none of that.
Okay.
Up in the county.
You were off parole, the way I do the math, less than a year.
Parole.
So you did your whole 8 years?
Ma'am.
What'd you do in prison to have to do your whole 8 years?
I was in SID.
For doing what?
Just tattooing, contraband.
Not following the rules while you're in prison. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you to a term of 6 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Here's a moment that really underscores courtroom reality. Support letters call him respectful, but the judge just demolished that narrative by citing repeated violations in jail and prison. The contrast couldn't be starker. Written praise versus documented misconduct. This is where the legal system forces accountability. You can almost feel the courtroom holding its breath as the judge systematically points out the inconsistencies, leaving little room for sympathy. The audience is seeing firsthand how credibility, history, and behavior intersect in real time to influence sentencing decisions.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal, and you're lucky that this was the agreement. Mr. Smith was generous. The fact is, you could have been enhanced to a second-degree felony because of your history, and you're lucky you weren't. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Ms. Holmes. You can go with the bailiff.
So let's break it all down. Denzel Lewis entered a guilty plea for a degree felony, faced serious questions about credibility and past behavior, and ultimately received the agreed 6-year sentence. The judge carefully weighed his criminal history, documented jail misconduct, and inconsistencies in his story against the letters of support from family and friends. The verdict underscores the importance of accountability, credibility, and adherence to the law. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.